Okay, dear, just remember I still under formal oath.
Yes, my lord.
Yes, Mr.
As the court pleases. So, Brigadier Miriam, just before lunch, we had dealt with a number of issues, and now we're going to be dealing with your investigations into the death of Dr. Haffejee. My Lord Brigadier Marion has set this out in his affidavit on page 15, paragraph 46 onwards. Brigadier, can you give a brief description of the steps that you took to look into the death of Dr. Haffejee?
Yes, my lord, thank you. My lord, during May 2019, I, together with the Director for Priority Crime Investigations, Warden Officer Khamanyane, Captain Matipa, and later Captain Mbele, looked into and investigated the death in custody of Dr. Haffejee. I received all available material from the original inquest, the TRC human rights violations, hearings, and the Section 29 hearings. My lord, none of the security policemen involved in the Haffejee case applied for amnesty, with the exception of Mr. Gopal, who was refused amnesty because the TRC found that his offences associated with Dr. Haffejee were not politically motivated. My assessment of the evidence that the investigation followed into Haffejee's death and the subsequent inquest in 1978 was a cover-up, my reasons for coming to this conclusion are as follows. During the initial inquest proceedings, affidavits were only recorded from Pettis, Ludovic du Toit, James Barra Taylor of the security branch. Aside from du Toit and Taylor, that were other SB members associated with the death of Dr. Haffejee who were involved in one or more of the following ways by way of intelligence gathering, surveillance, investigation, abduction, interrogation, torture, and subsequent death of Dr. Haffejee were Lieutenant McPherson, Brigadier Steenkamp, the commanding officer of the security branch in that division, Colonel Ignatius Gerard Coetzee, who was the second in charge of the security branch, Major Joseph Benjamin, formerly Munsami, Warrant Officer Schultz Governor, Sergeant B.R. Naidu, and Mr. Gopal, who was then a constable.
So, Brigadier, perhaps we can just pause there. Why, in your view, do you think that statements were not recorded from these individuals, and why they did not appear before the first inquest?
My lord, as said earlier, a close-knit circle was kept between the security branch in respect of deaths in custody, and they would only take the evidence or people of those that were trusted in the inner circle would make affidavits. And their affidavits would be a cut and paste, in modern terms obviously, but a cut and paste version of their versions as to what they say would have occurred. And in my view, my lord, if the members mentioned at that stage during the investigation by I think it was Colonel Sadler, had recorded all versions of all persons concerned with Dr. Haffejee, and all those versions were put under scrutiny by the judicial proceedings, it's my view that a different finding would have been made.
So, well, I have to put it to you, Brigadier, do you think a different finding would have been made by a magistrate sitting in 1977?
My lord, I'm saying that under cross-examination, it could have been, I'm surmising, that certain people would have been cross-examined by the counsel, by the prosecutor, and obviously by the presiding officer. And I'm just merely saying if all had made affidavits and had laid evidence, it could have led to a different finding.
Well, perhaps more information, more facts would have emerged. It didn't necessarily mean that that evidence would have led to a different finding. But be that as it may, Brigadier, it is evident from what we've heard in this inquest so far from former Constable Gopal, from former Sergeant V.R. Naidu, that the Indian members questioned were present. Obviously, there is some inconsistency in that evidence, but during the course of the interrogation, they were present. We know, of course, that V.R. Naidu suggests that the interrogation took place at another venue at Fisher Street. But why do you think they were particularly keen on keeping the Indian members away from the inquest, those who had been present, either at the apprehension and or the interrogation?
My Lord, in my experience, the Indian members would have broken under pressure and spoken the truth.
So you're saying they simply didn't wish to take the chance of these members breaking under pressure and making a mistake?
That's correct, my Lord.
And when I mean mistake, a mistake in keeping to the adhered version they were told to do.
That's correct, my Lord.
You say that Taylor and Dutoy blatantly lied at the first inquest as well as before their Section 29 hearings, and I don't think that that is in any serious dispute. You do make the point, though, that similar fact evidence of other detainees who had been assaulted by the security branch during the 1970s, that was not led in the first inquest. Why do you see that as a problem?
My Lord, during the course of the investigation that's subsequent to May 2019, we had come across people that were detained, for example, in the cells of Brighton Beach, of a person that was charged. I'm not too sure for what, but he was apparently in the cells at the time, Billy Dorsami. And he apparently was interviewed at some stage thereafter in the material that I read. And he hadn't, on the initial investigation by the investigating officer at the time, Colonel Sadler, that detainee was present in the cells in the morning of the 3rd of August 1977. But Sadler had not recorded his affidavit. And from the information that I gleaned on the papers, he was instructed to clean the blood in the cell of Dr. Haffejee.
Yes, although Brigadier Marion, to be clear, he would have been an absolutely crucial eyewitness. So we're talking about similar fact witnesses of detainees, other detainees who had experienced torture and assault and abuse at the hands of the security branch in the 70s, possibly from the same security branch members. From what I'm seeing in your paragraph 49.5, you're raising that as a problem, why such evidence was not placed before the first inquest court.
My Lord, yes, we heard, we knew at that time that many people were detained by the same security branch members at Fisher Street. Some of them led evidence now during these proceedings, but when called at that time to read evidence, we'd heard about Mr. Yunus Sheikh. We knew, it was known at that time that he was arrested by those security branch members, K.V. Modley, Governor himself, and many other detainees who were known to the security branch and the investigating officer at that time. And if their evidence their statements and affidavits were recorded at the time in August 1977, and their evidence of similar facts led, it obviously would give a different complexion, my Lord.
Would it perhaps have demonstrated to the court that abuse and torture was not out of the ordinary, it was part of a pattern of behavior on the part of the security branch?
That's correct, my Lord.
Let's now turn to the section in your statement where it's titled Assessment of the SAP Investigation. You appear to be setting out what you would have regarded as a proper and thorough investigation. Could you just outline briefly to the court what, in your view, the kind of investigation that should have taken place?
Yes, my lord. The version that initially was narrated at the very outset was that Dr. Haffejee had committed suicide by hanging himself with his trouser from the lowest crossbar in the cell, number 2 at Brighton Beach. Obviously that, my lord, just by looking at it prima facie on the face of it, this would have triggered a suspicion by the authorities to establish the actual cause of death and a thorough investigation as to whether any person was responsible for Dr. Haffejee's death. It is important for an investigation into the death of a person in custody or police custody, my lord, to be considered impartial and thorough. To achieve this, it needs to meet the following requirements. The investigator must be independent and impartial as reasonably possible. There must be a thorough crime scene or incident investigation. All available evidence must be collected and presented to the inquest court. All potential witnesses must be interviewed, their affidavits recorded, and they must be available to the inquest court. All material evidence must be properly marked and preserved so that subsequent chain of evidence can be demonstrated to the inquest court.
Now, Brigadier Merriam, you appear to be saying that those standards, those minimum standards, if I can call them that, were not adhered to in the Haffejee investigation, and you raise a concern about the investigating officer, a certain Major Scutter. What are your concerns about that selected investigating officer, Major Scutter?
Well, Lord, Major Scutter was from the district himself, a detective officer from the district itself, and from what I gathered, he lived on the station premises on the merit quarters as well. To appoint an investigating officer, even not from outside the district, and as from within the station or district precinct, in my case, is unacceptable.
And why is that?
My Lord, his objectivity would not be in keeping with an open mind. He would always have the so-called his colleagues' version in mind and not act objectively.
And Brigadier, you seem to have a problem with the fact that that Scutter's statement was recorded by one Colonel Herman Studler and later returned a signed type statement. What's your concern in that regard?
No, my Lord, it was a Detroit statement.
Was that Detroit statement?
Yes,
I beg your pardon.
Detroit, my Lord, was a person of interest in the whole investigation. From what I heard, from what I read in the material that was I researched, is that Stadler interviewed Detroit in the morning, let him go off, and he came back later in the afternoon and signed a typed version of the statement that was drafted by Stadler. That, in my view, Lord, is not acceptable. Herman Stadler, at that stage, my Lord, was at that stage the security branch head at the time of Dr. Haffejee's death, and he was a security divisional head in the then Durban Natal. Well, my Lord, he later became a Lieutenant General, if I may, my Lord, at head office of the detective services. And my research showed that according to the TRC records, it heard evidence to the effect, and I quote, "For many years, Herman Stadler was seen as a security police thief theoretician, almost intellectual. Nobody knew the enemy better than him. This week he presented to the Truth Commission a few kilograms of documentation and explanations on behalf of the organization called Foundation for the Equity Before Law. He told the Truth Commission that he tried to convince South Africans at that time that the liberation movements were very evil, or also evil. He also testified that the Commission attempted to justify the actions of the security branch. That I took the quotation from the South African History Archives collection AL 23283, my lord.
So, Brigadier Merriam, you seem to be suggesting that there was a cozy relationship between the uniform branch and the security branch at that time?
Well, this is the detective services who investigated the matter and the security branch.
Yes.
Yes. Yes, madam.
So are you saying there was a cozy
Yes.
relationship between those
Yes,
departments?
very much so, madam.
And while we're on that score, can you describe the dynamic that existed between the security branch and in particular the uniform branch and indeed other sections within the erstwhile South African police?
My lord, they existed, well, at that time, I know from experience, the security branch were called the elite of the South African police because of their so-called functions to investigate subversion and any issues that were anti-apartheid. And the relationship between them, my lord, existed in certain ways. In that, for example, at the divisional headquarters, you would have a head of the uniform branch, which commanded from the crime prevention, the station uniform officers, and the community service, or then the charge officer. Then you have the detective divisional head, who commanded all the investigative duties under his command, and then you have the security branch head, who commanded the one leg, which is the security branch. They had a relationship at that level in many respects, but there was a deep sort of compartmentalization at local level, the detectives, the uniform, and the security branch.
Well, let me put it this way. Was there a hierarchy between those different departments, and if so, who was at the top of the heap?
The divisional commissioner was. There was a hierarchy.
No, I'm talking about the departments. You've already said that the security branch was seen as the elite
Yes.
branch. So were they seen as perhaps the most important section of the old South African police?
That's correct, madam.
And were they in a position to get their way in relation to different operations when other sections of the police were involved? Could they issue orders and expect them to be followed by uniform branch members?
Absolutely, madam. Two uniform branch members. Yes, they can issue instructions to the uniform branch.
Yes.
Yes.
And perhaps if I can go further, if those instructions were of an illegal nature, certainly in those days, would there be an expectation that the uniform branch members would nonetheless comply with those instructions?
That's correct, madam.
And why would they comply with illegal instructions, given that they're supposedly police officers?
My lord, they acted in that way in order to, because of this camaraderie that they had, in terms of all of the policemen were fighting the so-called communists at the time. So they cooperated, even if it was illegal.
And if they were to refuse, what could the possible repercussions be?
My lord, the consequences were transfers, uncomfortable working conditions, and in some cases, my lord, some policemen were executed.
So there was an element of real fear on the part of uniform branch members when dealing with the security branch.
That's a fact, my lord.
If we can go to the crime scene investigation, Brigadier, you say there were some issues at the investigation in 1977 with the taking of photographs. Can you explain what those issues were?
Yes, my lord. My lord, the purpose of photographs is to record the scene as it was found. The photograph should have recorded the whole scene and focused on points of interest in the cell and the interrogation room. At the time, photos were only taken of the immediate vicinity of the grille door only, and the last rung from which Dr. Haffejee alleged to have strung himself by his trousers. There were no photographs taken of the whole incident scene itself, which is the cell number 2. During inspection in loco, my lord, we saw there were many points that were not photographed. Photos were taken of the highest grille bar in the cell door, the grille window above the toilet bowl, the other grille window and sink. We can see that, my lord, in Exhibit L3, Exhibit 22, 23, and 27. Had these photographs been taken and produced at the first inquest, it might have prompted certain questions to be raised.
And for example, what question could possibly have been raised?
The question, my lord, is that the presiding officer could have asked, why is it that the deceased did not hang himself from the highest point, which is the grill, the window grill with the mesh above the toilet seat, what was the most easiest way, as demonstrated in L3, and why would he have not strung himself up from the other grill or the highest point?
Thanks, Brigadier. You also take issue with the fact that no photographs were presented to the first inquest depicting the interrogation room. What's your problem with that?
Well, Lord, a full picture hadn't been given to the court then as to where the interrogation had taken place. It hadn't been exposed at that time to the court. As we know now, after the pointing out and the inspection in loco at the scene recently. And as I said, had this been done as well, it would have raised many questions by the presiding officer.
Questions such as what?
As to the distance from the interrogation room to the cells. Would it be possible for the deceased to have, on his own, walk to the cells?
Yes.
Or would he have to be assisted?
My understanding of the evidence, Brigadier, is that the security branch in the first inquest said he was interrogated in an office.
That's not true, my lord, according to the present evidence.
Yes, so if the photographs of the actual interrogation room had been presented, would they have been asking, why are you interrogating this man in a storeroom underground, in the basement?
That's correct, my lord.
Now, why do you take issue with the fact that it was the description of the incident scene to the first inquest was given by Dutoy and Taylor and not by the investigating officer, Major Scooter?
Lord, in terms of evidence in any matter led before a court, whether it be an inquest or a crime scene, one of the most important persons, if not the most important person, is the person, the investigating officer, that did the inspection at the scene. That would be, for example, your opening statement by an investigating officer to a court, to describe the scene to the court as to what exactly they found. For example, on the day of the incident, in this case on the 3rd of August 1977, the investigating officer would have told the court, when he entered the crime incident scene, this is what he noticed, and that had not been done.
And Brigadier, why do you find fault in the fact that it was Lieutenant Taylor of the security branch and another branch member who collected Professor Isidore Gordon, the chief state pathologist, and they brought him to the Brighton Beach cells? Why do you see that as a problem?
My lord, Professor Gordon ought to have been an independent witness, and to have been collected by the persons of interest in the investigation. That's now the investigation, the interrogation, and subsequent death of Dr. Haffejee is improper and irregular. He ought to have come to the scene himself. Now, I'm saying that in between picking him up and bringing him to the cell, a lot could have been discussed. to bring to the attention of the professor. Just by merely him coming there would obviously inform the court he's been independent, but in this case the suspicion arises that he could have been influenced in between from the time he had picked up to the time he had come to the scene.
So you're suggesting that it was almost inevitable that there would have been a discussion in that vehicle between Taylor and the other branch member and the professor as to what had happened, thereby shaping the professor's views, potentially?
That's correct, my lord.
You also take fault with the fact that there were multiple people at the death scene, including security branch officers such as Dutoy and Taylor, who were persons of interest, and that they were there before the scene could be forensically examined. Why do you take issue with that?
My lord, in terms of standard operating procedures of the South African police, when a person is discovered by the first responder, which is, for example, in this case, we heard is Nodia and or Meyer. As from that moment onwards, that scene should have been cordoned off and nobody allowed into the crime scene unless and until the forensic crime scene investigators had completed their investigation, had collected all the evidence, and the investigating officer, who in this case should have been Skitter, would first examine the scene and thereafter remove the cordon and allowed any other person who wanted to get in. But this had not been done. Taylor and Detroit had already gotten to the scene, and in my view, from the reading of the documents, from the reading of the material, they had contaminated that scene unbelievably. And therefore I say, my lord, nobody should have been allowed at the scene except the investigating officer and the forensic crime scene investigators.
And you appear to take a deep issue with the fact that the grill against which the deceased had been tied and suspended was not dusted for fingerprints. Why do you take such deep issue with that?
My lord, in my career, I had investigated numerous deaths in custody, but ironically, not a single detainee in custody. In all my investigations of deaths in custody in and around the country, one of the first things that I requested as the crime scene officer at that stage was to dust all aspects in the cell by a fingerprint officer. I'm a former fingerprint officer myself in the 80s, my lord, and I understand the importance of fingerprints. And in many cases, in my view, in my experience, fingerprints were picked up in the cell, on the cell grill, or on the objects from which it was alleged the deceased has hung. In this case, the crime scene had not been dusted for fingerprints at all. There's no evidence in the material, in the inquest, or from other investigators that were involved in the investigation that the scene was ever dusted. Had it been dusted, my lord, fingerprints of people that either it would have confirmed that there were fingerprints there and it would have belonged to certain persons, but this was not done, and in my view it was deliberately not done, not to the fingerprints.
So what you seem to be saying is that the importance of taking prints, particularly of the grill, is to establish who had been touching that grill and been in the cell. And as you say, this all should have been done before anybody else was allowed into the cell. That would have given a pretty good picture of what might have transpired in the preceding hours.
Exactly, my lord.
And am I right in saying that it would have been particularly important to have dusted for prints, certainly on the whole grill, but they really would have wanted to focus substantially on that lower part of the grill?
I say exactly, my lord, that's correct.
And why would they have wanted to do that?
My lord, in a normal course, in the normal investigation, one would have dusted exactly that grill from which the trouser was suspended, but in this case it was not done. And in my view it was deliberate, in that the prints of any person who had handled that grill would have been found if they had done it. But in this case it wasn't dusted at all.
Yes, so if in fact they had found prints of the deceased all over the lower part of the grill, that would have potentially supported the version of the police. But if in fact they didn't find prints of the deceased on the lower part of the grill, well, obviously that tells a hugely different story, doesn't it, Brigadier?
It does, my lord.
And if in fact they have found prints of other individuals, maybe even the prints of police officers or security branch officers on the lower part of the grill before being allowed into the cell. In other words, as you said, that cell should have been cordoned off and the dusting should have taken place. Then you could have demonstrated conclusively who had been touching the lower part of the grill.
Exactly, my lord. Let's take this scenario into consideration, my lord. That if prints were lifted of that portion of the cell grill, and in my experience, the people that were only allowed in that cell was the person detained, and or the visitation officers from the station charge office. So the only prints that ought to have been found there, if they had handled the print, was people from the charge office and or the detainee himself. Now, my lord, and if that had been done, and prints of Nodia and or Matala and or Meyer were found, in that they could have been eliminated, meaning that they would have explained, I visit the cells, and my prints would be lawfully, or would be there because I normally work in the cells.
Yes, but just to pause for a moment, you wouldn't have expected to find even their prints on that lower rung.
Not necessarily, my lord. In the normal course, they would be holding on the top normally to open the gate, but not at that lower point.
So you would have think it would have been absolutely elementary, just straightforward, that would have been the most important investigative task to be done immediately before the cell could be contaminated or disturbed by people, particularly persons of interest.
Without doubt, my lord.
And just finally on that point, if they had discovered, as sometimes fingerprint experts do discover, they don't discover prints sometimes, but instead they discover marks, white marks. What story would that have told?
My lord, in experience, where fingerprints were, they call it smudged prints. That would be, in most instances, attempts by people involved to wipe off the prints. You would find smudge marks. But if somebody holds a print, my lord, you will find anything from there to the tip of the finger, palm and fingerprints, if you hold onto a bar.
Yes, but to cut to the chase, if they find white marks, that suggests that the grill could have been wiped.
Yes, my lord.
All right, let's move on. You've already dealt with the failure to interview other detainees, and you've given the example of Billy Dorasamy, so we won't revisit that. You have a complaint that the cell in the interrogation room and the security branch vehicles ought to have been examined for traces of blood and fluid, but were not. Why was that a shortcoming?
My lord, based on the evidence at that time that was available to the investigating officer, one of the elementary things that he would have done, and one of the most important things, was to get the cell examined for fluid, blood splatter, and any blood that would have been found in the cell. As was found out in this case, my lord, one of two things. Either it was deliberately not done to find blood in the cell, and in my view, looking at the injuries of Dr. Haffejee, it's patently clear that that cell would have had a lot of blood on the floor, on the mat, and so forth. But that had not been done, my lord. And in my case, that was either deliberately done or mere stupidity on the investigating officer's part.
And if there were going to be traces of blood, it's quite likely that the interrogation room may very well have had traces of blood and bodily fluids.
Correct, my lord. And as we know at that time, they had, even so, on their versions that he was interrogated in an office, that office had not been examined for blood and fluids.
Now, Brigadier, you have quite a long section dealing with the shortcomings in the collection and logging of various evidential items and exhibits. We don't have time, and please, I must ask you not to read it because that'll take too long. But just give us a high-level summary. What is your complaint in relation to the collection and logging of evidence in the first investigation?
My lord, we heard at the first inquest that exhibits that were handed in, the shirt, the pants, the underpants, the trousers, the vest, and whatever, were allegedly found in the cell itself. There's no evidence from the investigating officer that's present on record, or that's present to us, that investigating officer had retrieved those exhibits from the cell, and that those exhibits were forwarded for forensic analysis. We have Neertling, who was the then head of the chemistry department of the Forensic Science Lab in Pretoria, visiting the cell, or visiting the scene, and when asked as to how he came into possession of the exhibits that were handed to him in a box, he said in his evidence, it must be the major, it must be the investigating officer, and in Afrikaans he said, Kenny, I don't remember his surname. So those exhibits, my lord, were taken to the Forensic Science Lab, they were examined. I believe he cut pieces of the material and he examined for human blood using a certain chemical, and he eventually came out with that there were no blood found or fluid found on the clothing. My lord, those exhibits that were seized and those exhibits that were examined at the Forensic Science Laboratory, the chain evidence is flawed. One cannot say what was picked up at the scene and described in the exhibits in the first inquest and what was examined at the Forensic Science Lab are the same. They are the same exhibits. The investigation from the very outset, from the scene of crime to the analysis, is flawed, absolutely flawed on the evidence before us, my lord. And Skitter, who was the investigating officer at that time, was given to understand a major, made a statement and was handed in the exhibit CC. Now, my lord, in the absence of that affidavit, we don't know what he said or what was said. We tried to get hold of this exhibit CC from all sources and available material. Unfortunately, like the many documents, that one has gone missing.
Right. So Brigadier, just to, and sorry to cut you short again, it's just that the end of the inquest is approaching us quite soon. We still have one more witness to deal with.
No.
But to cut that long story short, are you saying that what was not established in the first investigation and the first inquest was the chain of custody of those items? That's open to serious question.
That's correct, my lord.
All right. Can we move on to your next complaint about what transpired back in 1977? You say that aside from a criminal investigation, there should have been an internal or disciplinary inquiry, and yet there was none. Why is that a problem?
My lord, firstly, in every death in custody, in my view, and in the cases that I investigated, there is a disciplinary inquiry that's instituted, investigation to investigate neglect or any other conduct by way of the police in respect of the members of this community service center, by people handling the so-called deceased. And in every case, in my case, we investigated those cases, and whatever view or whatever decision had to be taken by police management or by the prosecutor ought to have been done. In this case, there's not a single shred of evidence that any disciplinary inquiry or criminal inquiry was investigated, despite all the inconsistencies that I've mentioned to court now.
So are you really suggesting, Brigadier, that there was no internal investigation because they didn't want an internal investigation to take place, in the sense that they were pretty much on top of the facts and they knew what had happened?
That is my version, but that's my suspicion, Lord, exactly what had happened.
Now, in your statement, you set out why you believe the police version cannot be sustained. You say it is doubtful, and you've basically set out reasons why you believe that it was fabricated and there was a cover-up. I'm not going to ask you to go through those reasons because you've actually set them all out already in your evidence, but if we can cut to the chase to your conclusion. You say in your conclusion that you suspect that the security branch were responsible for foul play in causing the demise of Haffejee. Just very briefly, why do you reach that conclusion?
Well, Lord, I believe that the truth was concealed from the very outset in respect of the investigation and to the death of Dr. Haffejee. The probabilities point to the possibility that Dr. Haffejee succumbed to death during interrogation. Alternatively, at the end of interrogation, he was in such a deliberating stage that he was killed to protect the SB from scrutiny. The cover-up to and the staging of suicide was done to conceal and abuse the brutal torture of Dr. Haffejee in custody, or in addition to mask the fact that Dr. Haffejee died under interrogation. I've demonstrated cover-ups previously on my evidence as to the cover-ups by the SB by the security branch was the order of the day, and this cover-up was consistent in the practice or in the investigation of Dr. Haffejee.
Thank you, Brigadier. There's no need to read the rest of your statement. No further questions.
Mr. McDonald, any question?
No, thank you.
Ms. Kisher?
No questions, my lord.
Yes, thank you, Brigadier. You stand down.
Thank you.
Yes, Mr. McDonald.
Thank you. Lord, the state has secured the statement of a further witness, a Mr. Hugh Derek Nordia, who has also secured his attendance via virtual link today.
Yes.
The state applies then that his statement be admitted eventually, and that he be added to the list of witnesses. It might be beneficial to the court to hear.
Sorry, what is that statement?
Lord, will be marked M6. I have placed 5. M5.
Oh, yes. You say it should be exhibit M5.
5. 5, correct, my Lord.
Yeah. Yes.
Thank you. Yes, my Lord. May the witness be either sworn in or affirmed. it will be a virtual
Yes.
test.
Mr. Nadir, please state your full names.
Hugh Derek Nadir.
Mr. Nadir, do you have any objection to take the prescribed oath?
None at all.
Do you swear that the evidence you shall give shall be the truth, the whole truth, and nothing but the truth, say so help me God?
So help me God.
Thank you. Yes, Mr. McDonald?
Thank you. Then, Mr. Nadir, how are you today?
Not too bad, thanks.
Good. So I am the prosecutor and will be assisting the court in reaching a proper decision in this matter, and obviously also with your assistance. Do you understand?
Yes.
All right, then I'd like to take you through your statement that you've provided to us today. At the time of this incident, you were in the employ of the South African police, were you not?
That is correct, yes.
And at that time, 1977 August, you were 19 years old.
Just a teenager, yes.
And on that night, you were on night duty, correct?
That is correct.
What time did that start at?
Night shift was from 9, shall I say 21 hours, 2100 hours till 0700 hours the following morning.
Now, you say that on that evening, can you tell us what happened? Do you recall?
Okay, what I...
You much earlier.
I'm trying to get a little bit closer to the...
No, that's fine. It's actually from the start of your testimony, from what happened on that night.
Okay, can you hear me now?
Yes.
Okay, so there was some gentlemen, I can't remember how many, that brought in a chap that evening, identified as being a political prisoner. He was to be detained there by us in a cell on his own. They spoke with him, we had basically no communication with him. And when they were done talking with him, he was escorted down to the cells where he was put into a cell on his own. You know, the cell visits for the rest of the evening went fine. The last cell visitation prior to handing over to the morning shift, when we opened the cells, we found him to be lying on the floor with his trousers around his neck through the bars of the inner cell door. His knees were pulled up slightly. Yeah, then we made necessary phone calls to station commander, etc. You know, in terms of what to do, that was something beyond our knowledge or experience.
Okay. Let's just clarify a few points.
Okay.
Now, these gentlemen that came to you, you say you don't recall the number, but were they more than 2 individuals?
I couldn't say for certain, but there was at least 2.
These 2. And are you able to tell us their race?
Sorry?
The race. Were they white, Indian?
White, as far as I remember, the detainee was an Indian man.
Do you recall
His appearance was Indian, yes.
Okay. Do you recall his name, the detainee?
Mr. Haffejee.
And the 2, at least, policemen that had brought him in, were they from the security branch?
And that's how they identified themselves, yes.
How did they identify themselves? Via their cards? Their police cards?
I honestly couldn't tell you for certain. One was a captain. That's all I remember on terms of identification or names or anything along those lines.
Possibly a Captain Dutoy?
Possibly.
Does the name James Taylor ring a bell at all?
That doesn't ring a bell. Detroit rings a bell vaguely, but I couldn't say for certain.
And they were dressed in civilian clothing.
Correct.
What time was the last time that you had checked on Dr. Haffejee?
That would have been 6 o'clock. The time of finding him.
Seems like we've lost the next game.
Sorry, it's just giving itself some thought.
Just tell the lawyer to phone the call.
I can see you. I don't know if you can hear me.
Yes, we can hear you. Just waiting for confirmation from the technical gentlemen.
According to my screen, your microphone is muted.
Just do a volume check.
Can you hear me now?
Now I can hear you, yes. There we go.
Maybe then proceed.
Yes, please proceed.
Thank you. As I was saying, what time was your last cell visit?
The last cell visitation was at 600 hours, and then the finding of the detainee in the deceased, as it turned out to be state, was just prior to 0700 hours before the morning shift took over.
So just let me clarify, you found the deceased at just before the morning shift took over at 6 o'clock in the morning?
No, that was just prior to 0700 hours.
Just before 7, that's when you found the body of Dr. Haffejee?
That's correct. That's correct.
Sir, did you testify at the inquest of Dr. Haffejee?
I did, yes.
Yes. Do you recall at all your testimony?
Not at all.
Okay.
I've tried to recollect, but
Right, let me refresh your memory.
I have no recollection.
According to what you stated at the inquest, you had seen Dr. Haffejee at 3 o'clock in the morning of the 3rd of August. And then you visited the cells again at 4 o'clock in the morning on the same day. And that's when you found the deceased's body. Does that ring a
I
bell?
was convinced it was. I was convinced that it was just prior to handing over to the morning shift.
Why were you convinced of
But
it?
I don't know. That's what I seem to recall. But it's 44 years ago. My memory's not as good as it used to be.
No, I understand, sir. And in fact, at that same inquest, you said that your last visit at 3 o'clock in the morning, Dr. Haffejee was alive.
He was alive at all the visitations prior to the last one where we found him deceased. If the time is just under dispute, I really don't know what to say.
Okay. But if your inquest testimony is to be believed that it was 3 o'clock, then it would be that 3 o'clock in that, or on that morning, he was still alive.
Yes.
Now, when Dr. Haffejee was brought to the charge office, do you recall through which entrance into the charge office he might have been brought?
No. Sorry, I can't remember that.
That's fine. Do you recall whether there was a Coke vending machine in the charge office or at the charge office?
There was no vending machine in the charge office that I'm aware of.
Was there one?
That I can recall.
Yeah. Was there one outside in the corridor leading towards the offices of the main building?
No, the corridor never had, but there was a lounge of sorts right at the end of the corridor. There may have been one in there, but you know, I really can't recall for certain.
And who were you on duty with that day?
I know Constable Mayer was there, and I think the sergeant's name was Mungwe. There was another constable that I can't remember his name.
Does Madladla ring a bell?
Was he perhaps the constable?
Yes.
I can only remember that he was shorter than the sergeant.
All right. Can you comment on what Dr. Haffejee was wearing when he came into the charge office?
If I have to suggest, because you know I really can't recall, I didn't pay that much detail. Just a trouser and a shirt.
I see.
You know, obviously shoes and socks and so on.
And do you recall anything about the colors of the clothing that he might have been wearing? The shirt color?
Not the shirt, but the trouser seems to trigger a memory of being a beigey, fawny kind of color, and the only reason that that sort of fits a bit is because it was around his throat.
I see.
When we found it.
I see. So you certain though that he wasn't wearing a safari suit, a two-piece, short-sleeved safari suit?
I really couldn't say.
But you are reasonably certain it was a shirt and a pants? Long-sleeved shirt.
Sorry?
But you're reasonably certain it was a long-sleeved shirt and a beige, fawny pants?
Sorry, did he say long sleeve?
I will question.
Are you adding long sleeve or what?
I will clarify that with the witness. Was the shirt long-sleeved or short-sleeved?
I couldn't say on the shirt, but the trousers were long trousers.
Are you able to comment on Dr. Haffejee's physical condition at the time?
To all appearances, as I can recall, he was in perfect health.
Was he not at all nervous looking, shaking, shivering?
I'm unfortunately not qualified in the psychology field, but he didn't appear to be, on my own opinion, you know, shaking, but he did look tense.
Was he perspiring at all?
I don't recall anything along those lines.
Are you able to comment on his hair at the time, the condition of his hair?
I'm afraid not.
Now, the inquest of Dr. Haffejee was conducted in 1978. Prior to that inquest being conducted, were you visited by advocates regarding the matter? at the police station?
I do recall that I was questioned by some state advocates in an office at the police station. It was district headquarters as it was those days, still is, I believe. That's, I believe that's where I submitted my statement, but I couldn't say for a fact.
Okay. Where was this office, this police station?
It's in Brighton Beach, and
Brighton.
the office was one of the district headquarter offices down the passage.
I see. And can you tell how many advocates were present?
I'm sorry, that's, I only remember being there.
Okay. Were any of the policemen that you had seen the previous night present, or that you had seen on the night of Dr. Haffejee's death present?
Not in the room when I spoke to the advocates, no.
Were they present there on that day when you had your interview with the advocates?
I honestly recall, I can't recall, I can't even recall how they summoned me to the room.
Do you recall the names of these advocates?
No, I'm sorry. In fact, I'm not aware that they gave their names. It was only pointed out that an advocate for the state.
I see. Now, according to the inquest, your statement was handed in and marked as an exhibit. Do you recall that?
I don't, but if you say so.
And according to the inquest, your statement is dated the 3rd of August, 1977, at 9 o'clock in the morning.
I can't verify or deny.
Okay. So, this is then the question. Do you recall when your statement was taken?
I can recall that I wasn't allowed to leave the single quarters, which is also part of the police station building. After that, I'm quite vague, I'm afraid.
Okay, let's just clarify that. When you say you weren't allowed to leave the single quarters, these single quarters are part of the Brighton Beach Police Station.
Correct, yes.
Okay. Who gave you the instruction? Well, sorry, firstly, was this on the day of the incident, the 3rd of August 1977?
Correct, yes.
And who gave you the instruction not to leave the single quarters?
I can't say for certain, but I think it may have been my station commander at the time.
What was his name?
It was a lieutenant, I can't remember what his name was.
Did they say to you why, or did he tell you why you could not leave the quarters on that day?
Only that I might be needed.
For what purpose?
That they didn't explain.
Did you remain on that day?
Yes.
Now, do you recall any other political detainees or prisoners that died at the Brighton Beach Police Station in 1977?
He was the only one that I'm aware of.
Did you not hear of a detainee committing suicide only on the 10 days later, Mr. Bayamkini Mzizi?
No. Absolutely not.
Now, at this trial, medical evidence has been led by Dr. Steve Naidu and by a Dr. S. Holland. They testified in respect of the time of death based on the medical evidence that was available to them. And they both put the date or the time of death as being before midnight, at least, on the 2nd of August.
Don't see how that's possible.
Why do you say that?
Because it was very, very late in the evening when the prisoner was taken down, and I seem to believe, or recall, shall I say, that it was post-midnight when he was taken to the cells.
I see. So then the doctors would be incorrect in saying that it might have been that the death occurred prior to midnight.
I'm only stating what I can recall.
Okay. So, tell me then, sir, the security branch at the time, were they considered the elite of the police force?
The hierarchy of the rest of the force is unknown to me.
So, would you be able to tell us at all, where would the security branch rank?
Yeah. To the best of my knowledge, they were this secret guardian division of the force, supposedly looking after our best interests. That's the best I understood.
Okay. And in terms of the hierarchy, are you able to say, were they the elite? Were they the highest ranked?
I'm afraid you're asking me to speculate now, and that's not something that I have knowledge to.
Okay. Now, you were a junior back then, obviously, and 19 years old.
Correct, yes.
Would it be then inconceivable to think that you would have to take instructions from a higher ranking individual?
No, the line of authority was such that even a constable who was recruited prior to me, earlier than I was, would be my senior.
Did anyone assist you with the taking of your statement?
Not that I can recall. I've never had anybody ever dictate to me what to say in a statement.
Do you communicate with Constable Mayer? He was our previous witness.
Him and I have been friends for many, many years. I lost contact with him a little while ago, and then just after Captain Bailey got a hold of me, I tracked him down again and asked him what was going on. And he told me that he'd already testified that it was just about what happened that night.
I see.
The details of which were not discussed, that I can tell you.
Is there any reason you didn't discuss these, what he had stated in court?
Because we don't want it coming up as a prejudicial statement.
But you did call him.
Either way.
So, okay, so then why did you look for him? Why did you phone him after such a long time?
I got a message from a friend who said that he'd been trying to get hold of me because Captain Mbele couldn't find me.
I see. Thank you. Nothing further.
So the court can just bear with us for a moment. Mr. Nordia, can you hear me and see me clearly?
I can, yes.
Great. Look, firstly, thank you for taking the time to be with us this afternoon and for agreeing to testify virtually from your home. It's appreciated. If I can just pick up where my learned friend left off in relation to the dynamic or relationship between the security branch and the rest of the South African police at the time. You described the security branch as the secret guardian looking after our best interests. Did you believe that at the time, that they were a secret guardian acting in the best interests of the people of South Africa?
I did, yes.
And if you did believe that they were acting in the best interests, I presume that you would have been supportive of what they were doing at the time.
I had no knowledge of what they were doing. That was beyond my scope of responsibilities or knowledge at that time.
Yes, you probably didn't know the actual detail of what they were doing, but in a general sense, you would have been aware that, for example, they would detain politically active individuals. They would keep them incommunicado. They would not be allowed access to families, lawyers, medical doctors. They would be interrogated.
I'm well aware that that people were detained under whatever the act was in those days as political detainees, but as to how they were treated, what access they had to whatever means that they were being deprived of or allowed or whatever, that's beyond my knowledge.
How long were you in the South African police?
I was recruited in my matric year of 1975, which was December. I went to the police college in 76, and I left late in 78 to become a master tradesman, a master apprentice, shall I say.
Right. But you were at least aware that the security branch was involved in the practice of detaining individuals that they regarded as a threat to the national security of South Africa?
Yes.
And you were aware that they would be posing questions to these individuals in order to ensure that they extracted the information that they needed to protect South Africa from various threats.
Well, you have to question them. Else you get an answer.
Yes, precisely. And did you never hear, either then or subsequently, that they had occasion to use what might be euphemistically called the third degree against these detainees or suspects?
Yeah, well, I only heard what one might refer to as passage rumor. I never saw any such activities, was privy to it in practice anyway, myself. So I honestly can't comment on it.
And this passage rumor that you heard, what was this passage rumor about?
The way they were being treated. But one takes such a thing with a pinch of salt, because all too often in the telling, things get embellished. So by the time you get to hear it, when it's been repeated several times, the version you're getting is not necessarily the true version, so therefore I disregarded what I was hearing.
And those rumours included rumours of assault and torture against these individuals who were being detained.
So I had heard at the time, yes.
So in fact, at the time, you didn't know for sure, but you had heard rumours that this elite unit, the security branch, was applying the third degree against detainees, even if it was only a rumour which you disregarded.
Correct.
And my little friend for the state asked you, where did the security branch sit within the police force? Perhaps I can just put it to you bluntly so that we don't beat around the bush, that they were at the top of the heap. They ruled the roost, and that other members of the branch, other members of the SAP were subservient to them. Would that be correct?
I have no idea.
You mentioned earlier that if you were given an instruction by a senior officer, somebody with a higher rank than you, if I heard correct, that you would obey that instruction.
Correct, yes.
If it was a senior officer, perhaps the rank of captain, and perhaps from this elite unit, the security branch, would you obey that instruction?
As long as it was a lawful instruction, yes.
Right. And would you have known the difference between a lawful and unlawful instruction at that time?
Within common sense, yes.
Well, that I think we do need to explore. So are you saying to this court that you would only have obeyed instructions that you believed were proper and legal?
Correct.
Even if a senior ranking officer came to you directly and said, I wish you to do something in relation, perhaps say to a detainee, which required you to break regulations. Let's assume for the moment that this person was a senior officer within the security branch. Are you saying that you, as a 19-year-old inexperienced constable, would stand up to that senior officer and say, no, go away?
My first point of reference would have been my station commander, and for him to act on my behalf.
And what if your station commander was not available? Perhaps it might have been late at night.
I would have then gone to the district commandant. If I was so convinced that what they're trying to tell me to do is not right, not legal, not proper.
And are you saying you had no fear of any repercussions from standing up to senior officers in the security branch?
Obviously, I would be very intimidated by them, but I would not have acted in what I believe an unlawful manner.
Are you saying that during the years when you were a member of the police, you never once saw policemen, regardless of rank and circumstance, carrying out anything illegal?
I saw minor infractions in behavior by members of constable members who were new to being policemen. Basically, how can I put it, that the authority of being a policeman had gone to their head and they thought they could abuse people by slapping them or something along those lines. But in each case, those people were dealt with.
And when you witnessed infractions, such as another police officer slapping somebody, did you report those incidents to your superiors?
Yes.
But you're saying that you never once saw somebody more senior than you committing any infraction?
No.
It just happened to be so that it was only more junior people to you who were committing infractions?
Was the people that I worked on shift with from various times, those are the only people that I ever saw something like that.
Yes, I must say that that is a remarkable coincidence that only those junior to you were carrying out illegal actions.
I didn't say junior to me, I'm saying they were constables or people on shift that I worked with. Could have been a sergeant. Yeah, those are the highest ranks that I worked with on shift, is up to sergeant. I never saw officers or NCOs behave in that manner.
All right, if we can just turn to the events in question that are the subject matter of this inquiry. And I'm going to ask my junior counsel to flash up an aerial photograph of the Brighton Beach Police Station precinct. And I just want you to confirm certain locations. Let's just see if the technical people can do this for us. Mr. Nordia, can you see an aerial photograph of the Brighton Beach Police Station precinct?
Well, I see a photograph. It seems to resemble the police station as I recall it.
Yes, so you'll see it fronts onto a road, which coincidentally is now called Hoosen Haffejee Road, although that wasn't the case obviously when you were there. Then you'll see a long building running parallel to that road, and it sits between the road and a parking lot. Would you agree that the charge office is situated at the far northern end of the building, fronting on a driveway?
Correct.
Can you recall, well, let me first put it to you, were you aware that the interrogation of the late Dr. Haffejee took place in the Brighton Beach Police Station building?
No, I was not.
But did you ever become aware of that fact?
No, never.
So are you hearing
It's
that?
news to me now.
You're hearing that for the first time this afternoon?
Correct.
Well, let me ask you, do you recall from which side of the building these officers, together with the deceased, entered the charge office?
The prosecutor asked that question and I answered it.
Please remind us.
I don't recall which entrance they came in from.
Okay, so you don't recall whether they entered from the outside of the building, or whether they were already on the inside and came through perhaps the corridor on the other side of the charge office?
I cannot remember. I'm trying to remember how many entrances there are in the building, but yeah, it's too long ago. I can't remember them all. The layout, I remember the basic layout, but where the doors all were, I can't recall.
Okay, no, it's fair enough. It was, after all, some 44 years ago. Would you be surprised to hear that the interrogation did not take place in an office, one of the offices in Brighton Beach Police Station, but rather in a storeroom in an underground basement?
That is news to me.
Yes. My question is, would you be surprised to hear that? After all, normally police interrogations would take place in an office.
I would be surprised to hear that quite correctly, yes.
Yes. And the very fact that it took place in an underground basement in a storeroom suggests that this was a very different type of interrogation. Would you agree?
Well, I have no knowledge of it, so I can't comment on it.
Yes, but would you agree? I mean, the mere fact, I'm just simply putting it to you, the mere fact that this interrogation did not take place in an office, but in an underground basement in a storeroom, that makes it a very different kind of interrogation. That follows, doesn't it?
Well, that would be my conclusion, yes.
Yeah. And would you also be surprised to hear that, well, let me bring you to the picture. The undisputed evidence is that he was apprehended early in the morning and was brought to Brighton Beach Police Station shortly thereafter, and the interrogations began sometime after 8 a.m., probably around 9 a.m., and continued throughout the day, all the way through to midnight, when he was allegedly brought to the charge office. The evidence before this honourable court, both the forensic evidence as well as evidence from a former security branch officer by the name of Mohan Gopal, is that during his interrogation he was brutally assaulted repeatedly. So now you have that context. Do you agree that it makes a lot more sense now why he was interrogated in an underground basement and rather not an office in the building itself?
To be honest, I'm trying to understand what that has to do with my involvement in this case, where I was working in the charge office. A prisoner was brought in, he was detained according to the prescribed methodology, and I'm being requested to speculate on things. I'm a little bit unsure here.
Yes, no, it's a good question. It's a very good question, Mr. Naudé, and we're certainly coming to that. But what I'm putting to you is evidence that before this court is undisputed, is that the man in question was brutally assaulted. And I simply asked you whether you agree that that helps to explain why he was not interrogated in an office, but rather an underground basement, because in an underground basement he would have been out of sight and out of earshot. That follows, doesn't it?
Well, as you say, it's where it was I have no knowledge of, so it was out of sight or hearing of my location, of where I was working.
Yes, it certainly was. It's the evidence of Mr. Gopal, who was present during that investigation, that in his view was most likely on the very other side, the bottom end of the building on the southwest corner. You descend some stairs into an underground basement, and down that corridor there's a a large storeroom. There's a possible another venue that is also underneath the building, but we don't need to go there. Now, would you also be surprised to hear that following his apprehension in Overport and bringing the deceased to Brighton Beach Police Station, there was no paperwork done, he wasn't booked in. He was simply taken to that underground basement and the interrogation commenced. That's not police procedure, is it?
It certainly doesn't sound like anything that I would expect officers of the police force to behave in.
Yes, indeed. For the moment, we can take the photograph off the screen. Now, you mentioned in your statement that on that evening some plainclothes men arrived, identifying themselves as from the security branch. Can I ask you, when you say on that evening, typically when one says evening, you think perhaps it might be the early part of that night, as opposed to that night. Are we talking about early evening, during the night, or, as the evidence suggests, around midnight?
My recollection was that he was brought to the charge office very close to midnight.
Right.
Either slightly before, slightly after, thereabouts.
And in your evidence in chief, you said you couldn't remember who was present, but you thought it was confined to white security branch officers.
Yes.
And in your evidence in chief, you also said you couldn't quite remember what he was wearing. You mentioned pants and a shirt.
Correct, yes.
And my learned friend put it to you, well, do you not recall him wearing a powder blue safari suit, a two-piece powder blue safari suit, short sleeve?
I can't recall that.
You then go on to say in your statement that you informed that he was a political prisoner and you were not allowed to communicate with him in any way, nor allow any other persons other than themselves, being the security branch, to have contact with this detainee. You then say when the security men were finished talking to the detainee and instructing us of those requirements, can you recall what the security men were talking to the detainee about?
No, not at all.
Because I'm curious. They had been, talking to him for the better part of, we'll have to calculate the exact hours, but 14, 15 or more hours. And now in the charge office, they were talking to him again. But typically in a charge office, it's the uniform members who have to talk to him about booking him in.
We only went through the procedure of removing belts and shoelaces, etc., and booking those into the required registers.
You then say he was stripped of standard items as specified for cell detention at the time, logged in the cell register and occurrence book. Now, there's the question of a handkerchief that arises in relation to the possessions that were removed from him. And you're aware that he was, well, you're aware because you found him. Did you recall that the trousers were in a sense, double secured by a handkerchief that was tied to the lowest rung of the grill in the cell?
I honestly can't recall.
Okay. Well, perhaps we will find a picture of that handkerchief and put it up. But you can accept that, at least according to the police photographs, a handkerchief was found secured to the rung of that grill door. But what is curious is that in terms of the possessions taken from him, a handkerchief was not recorded. So we're trying to establish whether it's possible that the handkerchief was simply missed out when he was stripped of his possessions, and we'd like to know whether you can shed any light as to where that handkerchief came from.
I can't recall anything about a handkerchief.
Well, let me ask you, when prisoners are placed in cells and their possessions removed, if you find a handkerchief, do you take it?
Generally not. To my knowledge, I can't recall that it was a criteria.
Right. So it was one of those items that was not seen as a potentially problematic item.
Yeah, shoelaces, valves, knives, etc.
Yes, so we now have the ligature, that's the trouser legs that were tied to the bottom rung of that grill, and the very top piece of material was a handkerchief which secured the trouser legs even more tightly. But we'll move on from that. Can I ask you what was the condition of Dr. Haffejee when he was brought into the charge office?
When you say the condition, can you be more explicit?
Well, did he seem to be in good health, in distress, injured, struggling to stand perhaps?
As I replied to the prosecutor on the same question, he seemed a bit tense, but you know, for me, if you're being detained, you'll be a little bit tense.
But he didn't come across as being injured in any way?
Not at all.
So we want to put up a photograph of an injury that appears on his arm, I believe his elbow to be precise. Can you see that photograph? And you'll see that there
Yes,
are
I can.
quite visible injuries on his arm, just above his elbow. Now, if he had been wearing a short sleeve safari suit, we don't believe that the sleeve would have covered those particular injuries. So would you agree with me, Mr. Nordia, that if he had been wearing a short sleeve safari top and those injuries were present at the time, you probably would have seen them?
Yes, I probably would have, but I don't recall ever seeing them.
Okay, we can take that on. All right, he was then taken to the cell. If I recall correctly, you were present, you accompanied the deceased to the cell?
Correct, yes.
And just remind us, who walked with you and the deceased to the cell?
There was from the security personnel, my colleague and myself. If I remember correctly, that was the only people that went with.
So your colleague and yourself, and were there any security branch officers present?
Some of the security branch were present.
Well, you mentioned that, as far as you can recall, in the charge office there were just the 2 white security officers. So are you saying it was those 2 individuals who went to the cell with you?
I can't remember who all from their side, but there was someone or someones from them that from the branch that was accompanied us.
Do you recall whether any Indian members of the branch accompanied you?
I cannot recall.
And do you recall the purpose of the security branch members in accompanying you and the deceased to the cell?
I can only speculate.
And what is your speculation?
They wanted to make sure he was going to be in a cell on his own.
And once you got to the cell, what did the security branch members do at that point?
I couldn't say. We left the cell together. They went their way, we went up to the charge office.
Did the security branch members not go into the cell?
I cannot recall.
And am I correct in saying that in order to get to the cell from the charge office, you have to descend a flight of stairs? I believe there are two possible flights of stairs from that charge office, but nonetheless, one facing the car park and another facing the driveway, but both would provide fairly straightforward access to the cell block on the other side of the car park. So you would have had to descend a flight of stairs.
One side of the charge office was stairs down to a petrol bowser. If you went out the front door by the car park, you'd walk down the driveway.
Yes, but in order to get to the driveway, you would have to descend some stairs.
I can't remember.
All right. Well, that's my recollection, and I'm sure my colleagues will correct me if I'm wrong. So when the deceased descended the stairs, did he do so with ease, or was he struggling?
I couldn't tell you for sure. I can't remember that.
But it probably would have been noticeable if he was struggling and had to be helped. That's something you might have remembered.
That doesn't mean that I would remember it now.
Right. But your evidence nonetheless is that he was injury-free and did not appear to be in poor health or discomfort.
Correct.
So to the best of your recollection, he had no issue in walking from the charge office to the cell?
To the best of my correction,
Knowledge.
my memory.
Yeah. Now, you say in your statement that normal cell visits and procedures to all the cells were adhered to for the remainder of the shift. When you talk about procedures, what procedures are those?
Checking the number of prisoners in the cells, that the cell doors are correctly closed, etc.
And it's also your evidence that there had to be hourly inspections of each person held in a cell.
Correct.
So if he was booked in at midnight, then he would have been visited every hour until 4 a.m. when he was discovered dead.
Correct, yes.
So do you recall when your first cell visit, and we know that it was cell number 2, do you recall when your first cell visit was?
The first hour after he had been locked up, when all the other cells were checked.
Yes. Now, it's the evidence of your colleague, Mr. Mayer, that sometimes you chopped and changed. It wasn't always the same 2 individuals doing the cell visits. Was it your recollection that you went on every cell visit?
I can't say for certain.
And when you did these cell visits, what exactly would you do on each occasion that you went to a cell?
We would check that the correct number of prisoners was in each cell, make sure the doors were closed correctly when we left.
So does that mean you physically entered every cell?
Correct.
And once inside each cell, what would you do?
Count the number of prisoners, make sure that there was nothing to be seen that shouldn't be there.
Yes, but did you talk to each of the prisoners and establish anything?
No.
So just to be clear, you would simply go in there, and if there's only one person meant to be in the cell and you saw one person, that was sufficient. You would then leave and carry on to the next cell. If there were 2 people there, you counted the number and then moved on.
Correct. We can't wake them up every hour. They wouldn't get any sleep.
Yes, so that's what I was getting to, whether in fact you were waking them up to find out, if they were okay and well.
They might be a detainee, but they have a right to have a night's sleep. So we never woke them up.
Right. And indeed, because if you were waking them up every hour, then they would never get any real sleep, and that in itself would be a form of torture.
Yeah, exactly.
So if somebody was lying down, say facing away from you, you're not waking them up. It is possible, I'm just playing devil's advocate here, that if someone in fact had passed out or even died, and they're in the sleeping prone position, you wouldn't know.
Under normal circumstances, no.
You see, I just want to put a few things to you. In your evidence before the 1978 inquest, my lord, I'm at volume A. It's page 330 of the original inquest. And page 346A of
346.
And my lord will recall that 346A was a separate page handed up because it was missing.
Oh. Yeah.
So, Mr. Nordia, you wouldn't have this in front of you, so I'm going to read it to you. Let me first ask you, you recall that you gave very short evidence to the first inquest in 1978?
I know that I gave evidence, correct, yes.
Yes. And a few questions were put to you by counsel for the police at the time, Mr. Boyson. And he said the following: now, did you make cell inspections on the hour at Brighton Beach? And your response is, I did, yes. He then says, and did you make your inspection at 3 o'clock? That obviously must be 3 a.m. as you said in your statement. And was the deceased then still alive? And your response is, he was still alive at 3 o'clock, yes. Actually, my learner junior has actually put up the page in question, but you recall giving that evidence and confirming that Dr. Haffejee was alive at 3 a.m. on that inspection, that cell visit.
Okay.
But you also concede that because he was in the prone position, you weren't able to determine conclusively one way or the other whether in fact he was alive or dead.
Well, at that point in time, he never had a pair of trousers around his neck.
Yes, no, exactly. But nonetheless, even though at that point in time he was not suspended from the grill, because you didn't wake him, you weren't able to conclusively determine whether he was alive or dead.
If he was dead, he wouldn't have been able to put the trousers around his neck. So obviously he was alive at that time.
Yes, that you're making a logical deduction, but that's not my question. And we can just confine ourselves to what you saw in your brief moment, and presumably you were only there for a few seconds. You simply saw a man. You made the assumption that he was sleeping and that he was alive, but you weren't able to make a conclusive determination in that regard.
Correct.
Yes. And then at 4 a.m. you returned, and that is when you discovered that he was lying on the ground and was now suspended, tied to the lowest bar of that grill. At that point in time, am I correct in saying you simply assumed that he had committed suicide by attaching himself to that grill?
Was the only logical deduction for me to make.
Right. It certainly had the appearance that, from your perspective, because he appeared to be alive at 3 a.m. and he was now dead at 4 a.m. and his trousers had been tied tightly around his neck and attached to the grill, that he had committed suicide.
Correct.
Now, I just want to put to you some photos of the cell number 2, which my learner junior will pull up shortly. Just go straight to the cell pictures. Okay, so I think first we want to look at a picture of the whole grill door itself. Yes. All right, so you can see from that picture, that's a picture of the whole grille door, and according to the version of the police, he was found suspended from the lowest rungs on that grille door. But I'm sure you'll agree with me that there are other rungs that are above that one. There's 2 in the middle of the grill door, and then of course there'd be the very top one itself. And we also want to show you pictures of the window grills. There were 2 windows in that cell. That if you're facing the cell from the entrance, on the left-hand side is a window with a grill on it, and you'll see at the bottom there are holes in that grill. And then if we turn to the next photograph, which shows a second window above the toilet bowl, you can see the Brigadier Marion standing on the toilet bowl, and at head level there is another window with a grill covering it, and again there are some holes in that grill. So I just want to put it to you, just as, since we're in the field of logical deduction here, if he was able to stand and move around, then it would have been a much simpler proposition for him to either suspend himself from one of the top rungs of the grille door, or one of the window grills, where again he could have stood and simply suspended himself, or even twisted himself, but just by turning around to strangle himself. So would you agree with me that if he was mobile and could stand, and it was his intention to commit suicide, using one of the window grills or the upper rungs of the gate grill would have been a much easier proposition for Dr. Haffejee? Do you agree with that proposition?
Easier, but not conclusive.
No, of course, unfortunately, in our game, Mr. Nordia, nothing is conclusive, and that's why we need these inquiries to weigh up all the different probabilities. But yes, certainly from our perspective, if it was a suicide and the man was able to stand and move around, then simply standing and suspending himself, or standing and just turning around, would have achieved the desired result, rather than the contorted version we have, where he's discovered lying on the ground with the ligature around his neck. But let's move on from that. I just want to put to you, and my Lord, I'm aware that we have reached 4 p.m. and
Yeah.
may I seek the court's indulgence for about 10 minutes in order to complete
Yes.
the evidence of this
Please do.
witness.
Yes.
The Natal Mercury published an article which covered your evidence, and my Lord, it's what volume is this? E. My Lord, it's volume E, page 1829.
Sorry, page?
1829.
One 829.
Correct, my Lord. In volume E.
I don't seem to have that page here.
My Lord, I'm not sure we have a spare volume E.
My volume A goes up to page 1223.
Are you sure it's volume E? My Lord, we have made an error. It appears to be volume H.
H. Okay.
It's the volume with all the press clippings, my lord.
Yes, okay. So the page 1, 2,
1829.
1829. Yes.
And my lord will see that this is a photocopy of a newspaper clipping, the Natal Mercury, Saturday, March 4th, 1978. And it's an article by the court reporter on the Haffejee Inquest. And the first part of the article deals with the evidence of Mr. Nordia. And I just want to put to you an extract from this article. It says the two constables checked the cells at 3 a.m. on August 3rd. Dr. Haffejee was awake and lying on his back on his bedding matting. I asked him if he had any complaints, but he just shook his head to indicate that everything was all right. He did not speak to me, Constable Nordia said. Now, to be fair to you, Mr. Nordia, we can't find that in the transcript of the evidence of the first inquest. But nonetheless, what is your response to that reporting in the Natal Mercury?
I have no idea where that comes from because I never spoke to that prisoner other than when we took his belongings in order to put him in the cells.
Right. So as far as you're concerned, the article in this Mercury report is incorrect.
I have no recollection of where that could come from.
Right. Well, it wouldn't be the first time that a newspaper got something wrong. Now, once you had discovered the deceased lying on the ground and tied to the grill, you then said in your evidence in chief that you made certain phone calls and various individuals then came to the cell. And it appears from your evidence that amongst the individuals who came to the cell were security branch officers, Captain Dutoy, Ludovicus Dutoy, and Lieutenant James Taylor. Indeed, the very same two individuals that had accompanied you to the cell had indeed brought Dr. Haffejee to the charge office. Do you recall that?
I recall that there was quite a few officious people running around at the cells, taking charge, barking commands. At that point in time, I have to admit, my memory is somewhat blurry because I was very nervous.
Yes. So you're not disputing that security branch members entered the crime scene or the death scene?
Not at all.
And indeed that they did so before a forensic investigation could take place, such as photographs and fingerprinting?
Unfortunately, at the time, I was not knowledgeable in the procedure of what should happen with such a circumstance. So I allowed these senior people to do whatever they believe they should be doing.
Yes, but now with hindsight, do you accept that actually they shouldn't have been allowed in the cell until the forensic investigation had been completed?
In hindsight, yes.
Yes, because they could have easily contaminated and disturbed the evidence.
That is a possibility.
And would you be surprised to hear that no fingerprints were taken of the grill or the crime scene?
That would be quite surprising, yes.
Yes. It's certainly a point that we will be highlighting to this court. Now, you've testified that the deceased was, aside from being nervous, had not been, from what you could tell, injured, and he was not in discomfort. I just want to put you certain extracts from one of the expert reports. This is the expert report of Dr. Naidu. My lord, that's Exhibit G24. Dr. Naidu is a forensic pathologist who was called by the state to give evidence in these proceedings. And I think I'm going to be dealing with two issues: his state of health and potential time of death. Now, the first extract, my lord, that's on page 11 of the report. The paginated page is 1586. And the first extract reads as follows. Dr. Naidu says, the inquest record accepted that Constables Nordia and Madlala saw the deceased alive at 3 a.m. and at 4 a.m. was seen dead. This evidence is seriously doubted and requires to be challenged. So the expert forensic pathologist says your evidence must be challenged in this regard. If we can then turn to page 14, I know that's paginated page 1589, paragraph 37 at the bottom. The injuries of the body surface and of the scalp, that's the head, chest and mesentery, that's the abdomen, in particular must be at risk of being a motive in this description, considered as having been due to significant forces and physically incapacitating, and that the deceased would have likely been in noticeable pain and in marked distress for the entire period after the injuries. If they were inflicted in stages, then the deceased condition would have been progressively worsened. And if we turn to page 16, my lord, paginated page number 1591, dealing with the injuries to the abdominal area, Dr. Naidu writes that the injury, which included bleeding or contusion, that's bruising, this can only occur with a massive abdominal blow, possibly by a fist or a kick. This would have been seriously incapacitating in that the deceased would, at that stage of the injury and for some time thereafter, would have been doubled up in pain and not only just winded, he would have been unable to sit or stand up or walk upright, and might have had restricted abdominal movements and respiration. He goes on to say that this blow would have been potentially dangerous and even life-threatening had the spleen or liver been damaged. He even suggests that blows of this nature might have caused death to the subject in question, Dr. Haffejee. My lord, the next paragraph, general effects of the injuries. With regard to the injuries individually and together, the deceased could not reasonably have been found to be simply awake and normal, and if the cell was last visited for inspection at 0300 hours, for at that stage he must have had sustained all the observed injuries. Had such visit been undertaken by an objective inspector of his condition, he would have found an injured person in noteworthy pain and distress if he was still alive after these injuries, if not in a state of unconsciousness after the head injury, or already deceased. If we turn to page 21, my lord, paginated number 1596.
Do I need to give them back the connection?
You've disappeared from one of our screens, but are you still there, Mr. Nordia?
And yeah, yes, but okay, now your microphone is back.
Did you miss much of what I said?
You were gone for at least a minute.
All right. Well, I'm going to proceed just because we are short of time. So, my lord, we're now on page 21. Paragraph 43 at the bottom. The seriousness of the bodily surface injuries after they were inflicted was such that the deceased would, in my opinion, have been in a state of intense pain and distress, likely unable to remain upright. With the head trauma, there is significant possibility that he could have been already in a stunned stupor or concussion, if not already unconscious. With the chest and abdominal trauma, the deceased would have been doubled up in pain, breathing with difficulty, if not in a state of sudden cardiac death from a cardiac concussion. And so Dr. Naidu concludes that in his opinion, and based upon the injuries and their effects, the deceased was to a great possibility either unconscious or actually dead at the time of the ligature constriction, and serious consideration must be given to the possibility of a homicidal slinging of the body in the position he was found. So that's the objective evidence of a forensic pathologist who studied the photographs and studied the post-mortem report. And he suggests that by the time you saw him both in the charge office and in the cell, he would have been in a very distressed and serious state. He would have been possibly concussed, unconscious, and in a great deal of distress, if not already dead. What is your response to that?
Several things actually came to my mind. I.e., does he say what time these injuries occurred? How much recovery time had the chap had? My own personal experience as a sportsman, I've been injured and I've recovered sufficiently to continue with whatever it was that I was doing. That gentleman was brought in, when he was brought into the charge office, he was walking on his own 2 feet, upright. When he went to the cell, he was upright, walking, and he was alive as stipulated.
Well, on the question of when the injuries were sustained, you might be interested to hear, and my lord, I'm now looking at page 24, paginate number 1599 of Dr. Naidu's report. Dr. Naidu says the following: the state of the full development of rigor mortis indicates a useful impression of the time of death. And he notes that Professor Gordon, the state pathologist, had described the rigor mortis as being developed completely and fully developed in all the joints he described when he examined the deceased at 7 a.m. in the morning. And he notes then that complete rigidity happens between 6 to 10 hours from the death, with a mean time of approximately 8 hours. So he says that given that medical knowledge, this would translate to death occurring between 9 p.m. the previous night and 1 a.m. that morning. Your response to that?
That man was alive. That's all I can tell you. And there was nothing in his behavior that indicated to me that I can recall from that time that he was in any form of physical distress.
And on the question of the injuries, the consensus between the pathologists is that the injuries were between 4 to 12 hours old from the time of death. So if we use the mean time of death as I just explained, that would say that virtually all the injuries were sustained between mid-morning and early evening, or at some point during the evening, and that coincides, was reasonably consistent with the evidence given by the surviving security branch officer who was present at the interrogation, because he says that is when the assaults and torture took place.
I don't know what you expect me to say.
Yes. So what I'm putting it to you is well, let me be fair to you. We're going to have to submit to this honourable court that based on the objective forensic medical evidence, that by the time you allegedly saw him in the charge office and subsequently placed him in the cell, and then again at 3 a.m. and lastly at 4 a.m., that on the probabilities, the man was already dead or in a greatly debilitated state, and that your evidence can't be relied on. And Mr. Naudé, that's why I asked you at the beginning. You were a young 19-year-old with the uniform branch of the SAP, confronted with very senior, experienced security branch officers. And I put it to you that you were told to toe the line and allow them to get on with their business. And you duly did.
That is fabrication on your part, I'm afraid.
It's not fabrication on my part. I am a legal representative for the family, and I'm simply putting the objective medical evidence to you and drawing a conclusion from it and seeking your response.
And my response is the man was alive when he came in there. He was alive when we put him in the cells. He was alive when we checked him in the cells.
No further questions, Your Lordship.
Ms. Keshav, have any questions?
No questions, my lord.
Mr. MacDonald, any re-examination?
No, thank you, Lord.
Just one point that I want to clarify with you, Mr. Naudé. Although there is evidence from the previous inquest that Dr. Haffejee was discovered at 4 o'clock in the morning to have died, you seem to think that it must have been a bit later than that, just before the next shift reported for duty. Am I
That's what I
correct?
seem to recall.
You seem to recall it was a bit later than 4 o'clock.
Nowadays, that's what I seem to remember. Whether that was whether my memory is failing, that I don't remember accurately on that aspect. I can't say for certain. I was under the impression, in my recollection, after some 44 years, was that it was just prior to the morning shift taking over.
Okay. Thank you, Mr. Naudé, for your time. That concludes your evidence. Thank you.
Thank you, my lord.
that concludes all the evidence we needed to hear in this matter.
Yes, my
Mr.
Lord,
Vani?
it has been a long and tedious journey,
Very.
but we hope that it was an important one for the families and the wider community.
Yeah. I suppose we need to get the transcripts now. You can then prepare the written documents.
Yes, my Lord. So that was one of the housekeeping matters I thought I would raise with you.
Yes.
And
Try to be as detailed as you can in your submission, so that I don't know if you would also want us to convene and maybe highlight something in the written documents.
yes, my Lord, we will be as detailed as we can, and we will also supply your Lordship with summaries of the evidence that has been led
Yes.
in both the first inquest and the reopened inquest.
Yes.
My Lord, we are of course reliant on the transcripts.
Yes. Mr. MacDonald knows what to do. I spoke to the judge president about that, and Mr. MacDonald will have to go through him to order those transcripts, because there are two departments involved. It's Department of Justice that reopened this inquest. As you know, the High Court don't belong to that department anymore, but I'm just a driver of this inquest as requested by the judge president, who was requested by that department. So it looks like they'll have to work out which department needs to pay for those transcripts. Whether we pay for them and they reimburse us, or Mr. MacDonald will have to pursue that with the judge president as soon as possible, so that we order the transcripts as soon as possible.
Yes, my Lord.
I can imagine it's going to be, I don't know how many pages, but at least I'm sure we would reach, what, 3,000 pages?
Yes, my Lord. Possibly that number. This inquest is not as extensive as some of the others, like the recent Neil Aggett inquest.
Yeah.
Although in that inquest, my Lord, we really did struggle to extract the transcripts. They were several months late.
Okay.
And of course we needed them for preparation of argument.
Yes.
So it is the responsibility of the state.
Yes.
And you know, that if it could be expedited, I think it would be of assistance to all of us, so that we can expedite closing argument and then finalise this case.
I would propose to Mr. MacDonald to pursue this as early as tomorrow. Will you be here?
Yes, my Lord. I will try to make an appointment with the Judge President
I think so.
to discuss the issue.
So that we
Get the ball rolling?
Yes. So that we have the transcript ready. We can then arrange, after the transcripts have been finished and your written arguments have been received, we can then arrange as to when we can reconvene for the final arguments.
Yes, my Lord. So as soon as we get the transcripts, then I think we can confer between the parties and
Yes.
perhaps make a proposal to your Lordship as to when
I do not know.
when we can a date for argument. I think
We need only one day.
I think 1 day should suffice.
Mr. MacDonald doesn't think so.
No, I
Oh,
agree.
you do? Okay. I thought you needed more than that. Okay. Now
Yes, I think
Let's
that there are
actually
only 3
inquest
parties
then.
in this case, so
Yes.
I think 1 day should suffice. So
I think so, yes.
we're happy to proceed on the basis that we wait for the
Well, it
transcripts.
doesn't look like the parties are in disagreement on parts of the evidence. Maybe Ms. Keshav might disagree with something, but yeah, so one day should be enough.
Yes, I think so, my lord. Yeah.
Okay.
My lord, the final matter from our side, the family have advised us that today, in fact, is the anniversary of the death of Hoosen Haffejee, the elder brother of Dr. Haffejee.
Yes.
We thought we should just place that on record as we close this inquest.
Thank you. The proceedings are then adjourned without a date, which will be arranged with the registrar
As the court pleases.
in due course. I hope they look after my records. I see some are lying on that table, and they should all be brought together here. So
Yes, I
that-
think some were, Mrs. Keshav borrowed some, and we used some for the witnesses, so we'll make sure they all get back
Thank
to
you.
you.
Mr. McDonald, would you check that your side, because I think we used your actually the files. Just make sure that they bring them together here. I don't want any evidence to be missing when we need to look at it or when I need to read. And yeah,
That's a good please.
thank you though. Yes, the proceedings are adjourned.
As the court pleases.
Court is adjourned.